Good afternoon, everyone. You'll see GoToWebinar's features include a questions drop down where you can ask any questions you have during the program. We'll collect them all and answer them either live during the webinar or afterward by email. Also, please notice the orange arrow to the left of the control panel to minimize it, and the handout drop down where you can download a copy of today's handout. Much of today's webinar will not be accompanied by slides. To adjust the video of the presenters for a better view, click and drag the edges of the video window. And now we'll proceed with today's webinar, as always, co-sponsored by the University of Florida Levin College of Law Institute for Dispute Resolution. Now here's Rodney Max.
Thank you, Kathy, and thank all of you who have taken the time out of your day to join us in this very important webinar regarding mass actions. Our firm, Upchurch, Watson, White & Max, a couple of years ago, actually right before COVID, recognized that we were being called upon as mediators, as masters, and even arbitrators in cases involving not just class actions, but from class actions to mass actions or just directly MDLs for resolving their disputes. And we realized that there were 4 members of our team, in addition to myself, Terry White, Steve Jaffe, and Lance Harkey, who had numerous years of experience in doing this. And we thought it'd be best not only to bring ourselves together as a center within the firm, but to use our experiences and our connections with those out in and around the country who deal with class actions and mass actions. So here we are today, focusing on mass actions with a group that I consider my friend. As I was reflecting on our experiences, when you do a mediation, you're with a group of lawyers for a 24, maybe 48-hour period in which you're trying to resolve the case. You prepare it, you mediate it, you may follow up. But when you're in a mass action, you end up with relationships, long-time relationships. And as you see Harold Hirschmann, Dee Miles, Ted Leopold, Sharon L on the screen, I will tell you that each of those individuals, they have my admiration, my respect, and they are part of a history that is a treasure to me, because we have indeed, over not just days, but weeks and months, gone through processes in which we have resolved the cases, the mass action cases that we have done. So I'd like to introduce them to you. They are your panel today. You're going to be listening primarily to. And I'm going to start off with Harold. Harold Hirschmann is out of Chicago. He's a senior counsel with Dentons, a trial lawyer for more than 49 years out of the University of Chicago. He's a member of the firm's litigation and dispute resolution practice. His principal areas are focused in securities, class actions, security class actions, takeover battles, business partner disputes, lender liability claims, and accounting malpractice suits. He's resolved more than 450 cases through mediation. Harold and I, back in the 90s, worked with an insurance company throughout the United States, and amazingly, after a trial that got out of hand, he got in hand thousands of policyholders who resolved their cases through his leadership. Ted Leopold from Palm Beach Gardens, Florida, partner of Cohen Milstein, is a co-chair of his firm's complex tort litigation and consumer protection practice. Ted received his JD from Cumberland School of Law in 1987. He's devoted to trial work focusing on complex products liability, environmental toxic torts, managed care abuse, consumer class actions, and catastrophic injury and wrongful death. He has been an interim co-lead class counsel in the Cape Fear River contaminated water class action and in NRA Flint water cases. Ted and I have done numerous cases, not only in the state of Florida, but beyond, involving the products liability work that he does and the mass actions that he gets involved in. So too, Dee Miles out of Montgomery, Alabama, Dee is with the firm of Beasley Allen, and he joined them in 1991, and he has become one of the leaders of that firm dealing with mass actions and class actions. He has been appointed to serve in a leadership role for plaintiffs and MDLs nationwide, charged with the responsibility of coordinating litigation for the entire country. He served as co-lead counsel for the team that secured the $28 million settlement between U.S. Financial Life Insurance and a class of nearly 12,000 policyholders. Dee and I'll tell you that this rich history that I have has an intersection between Dee and Harold. They were on opposite sides. Something that was otherwise a very adverse set of circumstances due to Dee and his firm's success in the courtroom, and then we evolved into a mass action success as we went from the courtroom to the negotiating table. And then there's the unique experience I have with Sharon Nelles. I've become very fond of Sharon and her talents in an amazing situation with one of the car manufacturers around the country who had some serious issues, both civilly and criminally. Sharon stepped in a negotiating role and dealt with very aggressive adversaries all over the United States and got those under control, not only within a class action, but opt-outs that arise from class actions. And that's where I had the privilege of meeting Sharon and dealing with those mass actions that were separated by geography and various issues. Sharon is with Sullivan Cromwell, their litigation group. She graduated from Boston College. She represents global companies and financial institutions and their boards in every aspect of critical matters, including civil litigation and related regulatory, congressional, and criminal investigations. She has represented clients such as Moody's, JP Morgan Chase, Volkswagen, Microsoft, and Diageo, as I understand it is pronounced. Now, with that, I'd like to get into the topic that we've got today. And it's mass actions, the when, the why, the how of organizing and implementing and thereby resolving these cases. You can imagine it's one thing just to initiate these mass actions and putting them together in pleadings, filings, MDLs, but then as you turn the corner into, is it appropriate to try to get to a table? And of course, getting to a table requires each side to understand what issues we have factually and legally. It's not done necessarily in a pre-suit way. In fact, it probably occurs after you've had a motion practice, certainly your pleadings and some discovery sufficient that all the sides understand what the issues are. So where I'd like to go with this, and I'd like to start with the plaintiffs, is to take the part that's when and why to mediate a mass action. Ted, Dee, from the plaintiff's end, could you speak to that for a few minutes?
Go ahead, Ted.
Okay, thanks, Dee. Well, first, Rodney, again, thank you for inviting me and all of us to attend this and be part of this program. Appreciate it. And it's been a pleasure to work with Harold, Dee, and Sharon on this project. I guess from the plaintiff's perspective, I think Dee would probably agree. Plaintiffs are always interested in talking settlement. It's usually the defense perspective that until they do which is understandable, until they do the appropriate discovery, they understand what all the issues are, they understand the risk of liability or how strong liability is, as well as what the damages are. It's a little bit hard to get everybody at the same place, certainly when we're talking about the type of exposure the defendants have and the type of damages that one has. In these cases, of course, we have to consider that we're not dealing with just one plaintiff, one-off claim. We're dealing with sometimes hundreds, if not thousands of claims. And, just take the Flint case, for example, there where we have dealt with over approximately 100,000 individuals, both minors as well as adults. So It certainly can take time in order to get to that point. I think it takes a lot of work at both sides in terms of mutual professionalism to try and get to a point where the parties are at the stage to mediate. And I think it also takes a lot of help from the court to understand and appreciate those issues and to get the parties at the point where they are ready to mediate. By that, I mean having regular status conferences, pushing discovery. Hopefully the court is helping to do that, getting the necessary foundation by way of discovery, whether it's depositions, on liability issues and damages teed up so that there can be a open dialogue and a good faith process. But again, I think that takes time, especially in these cases, as Dee can probably appreciate, and everybody, you know, just getting past the motions to dismiss, getting all the briefing, you know, that's a 12 to 18 month process before we even get to that point. So these are very long, protracted type of litigations before I think you even get to that point.
Yeah,
Yeah,
let me echo what Ted said, and I can say from experience in both MDLs, class actions, and mass torts, that, you know, to get to an early, and let me say this, the sooner the better on mediation, always. And Ted, he said that to begin with, I agree with him. But you got to start with, you know, some really good pleading. And I know Ted does this, but, you know, one of the things we do is if I have a case and someone's brought it to me, I always want to take a group of lawyers who just work on facts. For example, in an auto defect case, there, you know, we have some guys that are just experts on that. And I'll put a group in charge of that, and I'll put a group in charge of the law. And then, you know, so they're looking at the law, we're looking at the facts, and at some point we'll have a meeting where we'll marry the two together. So most of the time you're eliminating causes of action and you're tweaking your facts. And then of course, then you get a complaint and you tweak to death. But if you do that, and as part of that process, another important part is, you know, I know Ted does this, but you have got to have an expert helping you with the pleading, because good pleading is going to get you to mediation. And if you do these things ahead of time, where you have a good expert on liability, and you actually, maybe you don't have your damages model yet, but you've got somebody who's giving you an outline of what your damages model will be, and you do all that before you file your case, usually your complaint will reflect that you know what you're doing, and it sends a message to the defendant that you know what you're doing, and you may get to an earlier resolution. In my experience, has been when I've done that, I get, and you know, part of this is relationships, depending on who's on the other side. Sometimes they'll call you or you'll call them, and you'll discuss your complaint, and they'll realize, hey, I think these people are really going in the right direction. And if the defendant knows they have a problem, they're more willing to settle it up front if they know the plaintiff is on the right track. And then, you know, it's just a matter of, okay, well, how do we get to resolution? I would say probably, Ted, you're right, about 80% of the time, once you get past motion to dismiss, you're in a good position to settle. But oftentimes, if you do the things I'm talking about, just good pleading, you can get there before that. In fact, I'm working on a case right now where we never got to the motion to dismiss. We froze it, but we did brief it. And we froze it, and then we're in negotiations, and soon we'll be announcing the settlement. Again, good pleading. Experts up front have a good idea what your damage model is before you file the case, and that will lead to maybe an earlier mediation than you ever dreamed of in a regular case.
that's great. Thank you, Dee. I appreciate that. Harold and Sharon, you've got the defense perspective. Do you mind articulating your thoughts on that?
Sharon, you want to start?
Sure, happy to. And let me echo what I think Ted said, which is how happy I am to be here, and that always makes me so happy to work with Rod, and it's been such a delight to get to know all these gentlemen. But hopefully Ted and Dee in particular will remember, because I agree, like who's on the other side of the table matters a lot. And sometimes the when and the why is very much focused on who you're dealing with. I absolutely agree that the when is probably much more difficult for the defendants, and you know, who often are dealing with issues of not only internal counsel and their need to show or potentially show strength. But senior executives, a lot of the kinds of cases I do involve senior executives, board members, and it's can be difficult for people to wrap their heads around early mediation. This often needs to be some kind of, as we say, an inflection point, whether it's the loss on a motion to dismiss, a loss on summary judgment, a bad deposition, or sometimes it's just sheer exhaustion. And a lot of times I get phone calls to come into cases that have been going on for 10 years, and to see if a new dynamic can lead to a resolution. I do often advocate that defense should not be afraid to talk to lawyers, should not be afraid to talk to their clients about seeking an early resolution. That can be part of the why. Why? Because it can take years to resolve the kinds of cases that are mass actions and class actions. There can be a huge benefit to thinking about reducing your inventory and start setting some cost parameters around what you can do in a mediation. It costs a lot of money to just maintain these actions for a long time. Attendee may have a staple of experts. You're probably dealing with this for the first time. One of the things I think that I consider incredibly important is just getting relationships with your mediator. I mean, if you have a mass action, like getting to know someone like Rod early, and Rod and I, as he noted, spent a couple of years traveling all over the country, resolving about 4,000 cases together. I would like to suggest that I think Rod and I had trust from the beginning, but by the end, it was we knew what we were doing when we walked in the room, and it was really helpful to my client in dealing with the absolute mass of exposure, to know that there was a neutral who understood how to get things done that worked for them. And then, of course, taking out a why. The last why is really, again, an early resolution can make a lot of sense if you have a situation that is headline inducing. Maybe it's not the cost or even the threat of liability. Maybe it's just the PR implications that can really drive you. Now, I'll kick it to Harold, who I know there are other implications, and I think one that maybe he can address in particular and should is the why of dealing with your carriers, as well as anything else. But I know you have special skill sets here.
I also, really am grateful to Rod for giving us this opportunity to go back over the history of what we worked on in the 90s and how it's evolved. I think that, what Dee said about the plaintiffs focusing and being creative in presenting their legal theory is important, because, as Sharon said, it's a process of education, and it depends on the ability of the plaintiffs to be persuasive about the source of liability or the source of damages, that then leads the companies, unless they've already faced government action of some kind, which is also a trigger for many mass actions, is that the companies do not come to these simply because they have a lot of individual lawsuits. They come because they're a focus of public attention, the press and the regulators. And Sharon didn't mention it, and maybe we will get into it a little bit later, but on the defense side, there's usually two audiences. There's the company, and then there's its insurance carriers. And so you need an educational mechanism at both levels. because there are times when the insurance carriers are more willing to discuss resolving things because mostly it's their money, or there are times when the company is so exposed that the insurance carrier's contribution is really not significant given the amount of exposure. But each of those audiences, the defense counsel, the company, and the insurance carriers are helped by understanding the strength of the plaintiff's situation. I remember a friend who was a patent lawyer, plaintiff's patent lawyer, and he said that when he filed the complaint, he had an affidavit of a noted expert about why the patent that he was going after was invalid. He attached a motion for summary judgment so that the patent holders knew what he was about and where he was going. He said, you know, there's no point in hiding these things. You really need to get people's attention, and that's the way he did it. The other aspect that Ted and Dee mentioned, which is the length of time until some of these things get organized. The defense obviously has certain powers if it wishes to face a more organized group, and obviously one of them is MDL. But in Alabama, at least years and years ago, we were able to get an order from the Alabama Supreme Court consolidating all of these individual cases in Alabama for discovery purposes and to set an orderly trial schedule. And that was really critical. That state organization was really critical to getting the plaintiffs themselves to be willing to come to the mediation table. So I think that that's a question for the defendants, which is whether they do want the plaintiffs to be organized. And in like mind, with respect to the plaintiffs, many of them aggregate their cases through advertising and solicitation. And there you then have a question as to whether there is a plaintiff's lawyer who you think would be amenable to some kind of early resolution, assuming that's something that you are interested in. And you can focus your efforts with respect to mediation on a given plaintiff's lawyer with his inventory or her inventory. And that will also go some way towards signaling what a method for resolution exists. Rod, I only have one thing to say to you besides thank you, which is I've been at it for 53 years, not 49.
There you go. All right. Well, I stand corrected on that. But thank you, Harold, and thank all of you for your initial comments. I think what we've heard is the why and the when of mass action mediation. Now let's move over to how do you make it happen? What is it that now has got to be done to initiate the process? And I'd like to turn it back over to the plaintiffs to begin that. Ted, Dee, you wish to address that, please?
Dee?
I'll take it, Ted, since you took the last one. Again, I will reiterate in what Sharon also had agreed on, which is, you got to have a relationship with the other side. In this case, but first of all, I want to say thank you, Rod. I didn't have a chance to say thank you as I jumped right into the substance. My fault there. But thank you for inviting all these people. And look, I've had interaction with everybody. This is a great panel. I had a limited role in VW with Sharon. She had a much bigger role in that case than I did because it was in San Francisco. And Elizabeth Cabraser, our good friend, was the lead in that case, but that was a great case that had a lot of these complicated issues in it. I've known Ted for years, and of course, the stories I'm sure that will come out in the next probably 45 minutes about Harold and I's experience with Prudential. What a great story! When you hear that story, you would first think, how in the world did they ever become friends? But we've been friends ever since. So what a great experience that was. Again, back to how do you make it happen? So again, relationships. You got to know the lawyers on the other side. I heard Harold say, well, you got to be able to have a lawyer who's got some sort of leadership amongst his group. That's important. It's also important to have some past experience with the lawyer, maybe even in a mediation setting. But it starts there to me. I mentioned earlier it starts with good pleading, but then how do you get to mediation? Well, you got to be talking, and in order for you to get to an agreement. The way I do it is I usually will call somebody and say, well, here's what I know about my case. And I think that you're going to be spending a lot of time and money to get to the same conclusion that what I'm about to tell you. And then I will explain that to them. The great thing about having those relationships and the great thing about the federal rules of evidence is you have Rule 408. And Rule 408 protects you. So you can reveal things in a conversation with someone you can trust about the case to advance the ball without it being held against you later. And I know, for example, with Harold, we did that. And we were able to trust each other and take a leap of faith. And ultimately, we got to a result that everybody was happy with. But I think the most important thing to me is the relationships. Then you're going to, there's also the structure. How do you get there? Every case has its own sort of dynamics. I know, Ted, you're probably going to talk about your case, so I'll leave that topic really to you because you have an interesting case where you have both a class and mass tort. And you got to be able to have a plan before you make that call to that person. You have a relationship to discuss whether or not you can achieve a settlement for the entire universe, because we all know as plaintiffs, that's what you really want as a defendant. You got to have control of the universe in order to get to a resolution. And we as plaintiffs, need to help you get there. So I think those two things are probably, how to get it started. Ted, I'm sure you have some thoughts on that.
Yeah, thanks, Dee. I think you touched on a lot of the issues, but maybe if we expanded it out a little bit, because there are so many dynamics to address. And I would venture to say we've all had these experiences both on the defense and plaintiff side, or at least that Sharon and Harold has had to deal with the plaintiff side, which is it's one thing to have a relationship between the plaintiff and defense attorneys, but in these mass actions, you are dealing with not one plaintiff's attorney, not two, but sometimes dozens and dozens of plaintiff's attorneys. So how do you manage all of that by way of the purpose of discussions of today is to get everything to mediation, because you're going to have, fortunately or unfortunately, different factions within the plaintiff side unless you can get everybody on the same page, which often in these mass tort type of cases can be difficult because, as Harold mentioned, you have attorneys who are mass marketing cases, you have other attorneys who have a certain number of cases via referrals, whatever it may be, and some attorneys may have a large number of cases, some may not have as many cases. So there's a lot of different interests that are involved. And that's why I think coordinating this all through the court, even in the mass action perspective of leadership roles, having the court make a leadership structure, I think is very important. As Dee mentioned in the Flint case, for example, although probably 80% of the defendants have settled, there's still private engineering firms that have not resolved. And in Flint, there are both individual cases as well as class action. So all of those had to merge together whenever there were negotiations with the state of Michigan or the former governor or private engineering firms, et cetera. And again, getting everybody on the same page, getting everyone to agree has been quite interesting. And I'd be curious from the defense standpoint in these cases also, generally, I think it's the view that defendants don't want to piecemeal the settlement, whether in a class action slash mass tort. So, you know, unless everybody is on board, can a few handful of plaintiffs go to the defendants, perhaps if they have large volume of cases, and settle? But then the defendants are still going to be hanging out there, still litigating these cases for a number of more years. So it's hard to get to a point where there will be global resolution, which of course is what the defendants, which I can appreciate, always want. But with all the dynamics, it's oftentimes very difficult to do that.
I'll enter this before I turn it over to the defense side. That what I have found in mediating these cases is that pre-mediation meetings, getting all of those plaintiffs' counsel together, trying to get them organized, sometimes successfully, sometimes just to open the door to that, is very helpful. And to try to begin to get process, because what the defense is looking for is really just what you guys are saying, Ted and Dee, and that is, you know, if they're going to enter into this effort, they want to know that it's global. I'll never forget being in Sharon's office. I think it was the very first time. I'd never met her before. We had all of these people. We had all these people on the plaintiff side in the room. They even did a PowerPoint presentation. And that PowerPoint presentation was their mechanism of advancing what their issues were and how they're going to play it out. And they all felt really good about their cases. Sharon did a great job of listening, and we said, okay, we're going to go forth. And thereby, one group at a time. And I think Sharon's masterful strategy was, let's start at the top. But let's begin to get the leadership taken care of, and the others will follow through. And sure enough, while it took a time, because it was in different cities all over the United States, we took care of that leadership, and we also took care of those underneath it. But those the pre-mediation efforts, I think, help give a base and a foundation to what goes on afterwards. Sharon, Harold, do you wish to comment on that?
I just want to add one thought, which is, and it's a plaintiff's issue really, which is whether you have multiple defendants in the same case. Because the minute you add multiple defendants, you increase the difficulty of resolving things for each of the defendants. And you force the defendants then to have a unified front, and you make it even more difficult to create an environment where, you know, some kind of early resolution is possible. You know, when you have one defendant, they can look at their interests, they can look at the risk, they can decide whether or not they want to settle all cases or almost all cases. In the prudential situation with Rod, we resolved 429 cases, I think, and then I had to try one. But you know, that's a big difference than having to try 40 cases or 50 cases. And so the defendant has to make a decision about whether it wants to, in essence, if you'll excuse me, clean out its inventory and limit the number or kinds of cases that it wants to try. And, you know, then we go back to what we've already said, which is, you know, who are the plaintiff's lawyers? How did they get their cases? What kind of risk factor do they pose? Where are they? Can they be consolidated in some way, shape, or form, either in state or federal court? And that gets you to a position where mediation is possible. If you can't reach consensus among the defendants, then each defendant has to make a difficult decision, especially because of indemnification and cross insurance and things like that, as to whether they can go it alone if they want to. And that becomes itself, obviously, a complex set of decisions. And so while it seems at first glance that a case with a lot of defendants is a good plaintiff's case because they can get some money from somebody, I'm not so sure that that's really the best strategy if it's a situation where there are going to be many cases which are essentially making a similar claim for plaintiffs. And that requires, as Dee said at the beginning, a great deal of thought and frankly some courage to focus what you're doing rather than try to have the broadest possible set of claims and defendants.
Very good. Sharon, your thoughts on that regard?
Sure, I think Harold has done an excellent job of convincing Dee and Ted to drop his clients. And I'm going to be left with this. But it's actually a really interesting point, and one we didn't have in the when and the when and the why and the when is sometimes you can find yourself forced into mediation when the situation where there's joint and several liability, and your options are to participate now or potentially be left holding a bigger bag or a bigger piece of a bag than you thought you might be. I don't have much more to add. I think we've touched on most of this. I think the key in the how is the relationship, and one thing, and we have it in there, is the outreach to plaintiffs to get something started. But if that feels strategically difficult for your client, another reason to have a mediator early and on board, ready to go, is you can use the mediator to neutrally go in and start talking and saying, I don't know, but would you be, if I can get them to come, would you want to come? I've worked with, Sharon on some of these other mediations. I am indeed not a fan of a piecemeal settlement. In fact, I once did a mediation for a major banking institution and trying to negotiate a resolution with the federal government on with many different agencies. And one agency said, I don't want peace, I want global peace. And then they say, okay, global peace, meaning we bring in the other federal agencies. I said, no, I want the plaintiffs too. I want global peace. So global peace is what we're going for, but you don't always get it, and you can't always get it, in which case finding the right other party to begin with, as Rod talked about, is really, I think, the dance. And then you work down your inventory or until you get to the right cases.
Rodney, if I could just raise one issue, because I thought you raised an interesting issue, as both Sharon and Harold did as well, which is knowing everybody to work with on the other side. And oftentimes in these cases, the plaintiffs generally aren't concerned with insurance companies, because you're dealing with big companies on the other side who, from the plaintiff's perspective, they're big companies and have plenty of money to pay it, and insurance is their issue. It's not our issue. However, it does become the plaintiff's issue when the companies are refusing to negotiate until the carriers come on board or help defray a lot of both not only litigation costs, but also to pay judgments or for a settlement. So it's become quite interesting. I actually have two cases right now that are certified, and both of those cases, the defendants generally want to settle, but it's the carrier, they're fighting with the carriers. And so that I think is, and we can say on the plaintiff side, well, that's not our issue, but at the end of the day, it is our issue, because, unless they can get over their own internal difficulties and figure out who's going to cover what, or who's going to pay what percentages, or whatever their dispute is. One case, in fact, they have a deck action going on between the two of them. So and now we're certified and getting ready for trial, and they're still, fighting amongst each other about who's going to do what. So, these are, I think your comment is very cogent about trying to get everybody in the same room. And sometimes when they're in the same room, it helps. Sometimes they still amongst each other are in separate rooms. The carrier and the insured are fighting with each other. So it can be quite complex situation.
Well, Ted, that's very interesting. I'll never forget, down the street from Sharon's office in New York is AIG. And they were a part of a huge tower. And I suggested that in a pre-mediation way, mediation was scheduled about 45 days out of this particular meeting. But this meeting had the following agenda. A, plaintiff's attorney comes in, plaintiff's attorneys come in, and they make a presentation. Not just the defendants, but their carriers, all of them, the tower, were there to listen. That took about an hour and a half. When it was done, plaintiffs leave. They left with a demand on the table. They left. They left New York. We stayed there for the remainder of the day to let the tower work through issues such as verdict evaluations, settlement evaluations, and how they were going to work together, which 45 days later, we went to a mediation and we were effectively able to get that to not just resolve, not just get a direction to resolve, but we actually in 2 days got it resolved. But it's that pre-mediation organization among carriers who all have their own. And that 45-day gap gave them time to, having heard it, collectively talked about it, now go back into their own camps and get prepared for it. Which brings us to the next topic, which is, all right, now we've got an agreement to mediate. What do we need to do in getting ready? And there are, as I've suggested a couple of times, the pre-mediation, but as important, what are the protocols? When you're dealing with mass actions, as you all have alluded to, it's not just one plaintiff. You got to get everything done. And so, and many times plaintiffs counsel don't like to hear it, but there is a gridability issue. How do you grid these groups of cases? Now, it's one thing for the defense to do it. It's another thing for the plaintiffs to do it. Somehow there needs to be a collectivity of that, so we're on a similar page. This time I'd like to start off with the defense. Maybe Sharon, I'll let you go first, go over to Harold, and then we'll go to the plaintiffs in terms of the protocols. Once we now have got this mediation going, what do you see as the ingredients for that?
Sure, and some of this bleeds backwards into what we were just discussing, and because I think the how to get things started and what it looks like can influence each other. But what I would say, one of the first things we absolutely want to do is choose our mediator. And in fact, I sometimes think about the mediator before I do any kind of outreach to plaintiffs, though I will say as a general matter, I usually ask the plaintiffs who they would like to mediate with, and unless there is any bias that's really problematic, I would almost always take their choice. I find at the end of the day, usually there are, in the kinds of cases I think that are mass action cases and this big, they're sort of, you generally tend to get to agreement. But I think first you want to think about who you want or what kind of mediator you want. I think then developing your thoughts about what the mediation protocol should look like is obviously including educating the mediator, right? And you talk about gridability. I agree with that. I think one of the first things on the defense side we do in a mass action is really sort of come up with either some kind of gridability, right? So we have some ability to value cases in different ways. Or what we do is we decide where, there's some kind of something formulaic, and it's a matter of educating and getting assistance with the mediator to start being able to get plaintiff's counsel comfortable with the idea that things are going to have to be mediated from the defense side under a certain formula. But that and look, sometimes they don't agree, which, really that's to be expected. But figuring that out, like what works for your clients and knowing how to go, because I think in a mass action, it's much more difficult. You know, look, when I really enjoy mediating, and I find it's, I always encourage people to be really fluid in a mediation and open-minded. But when you're dealing with 400 or 4,000 cases, there does need to be structure. So I think identifying a structure is key. Harold has articulated perfectly, and we can't, as have all of you, and we can't underscore enough like how critical it is to get the carriers on board. Like, there's been many times in my life, including today, where I have been unable to engage in a mediation because the tower is not ready. And like, you know, sometimes, you know, the clients say, how do we move this into a mediation? I say, we got to go out and lose something. You know, but really, you know, if you cannot get the tower, you're not going to go anywhere. And so it really is all of our problem. And do work, as you say, Rod, I've been lots of those situations, and known to the plaintiffs and sometimes unknown to the plaintiffs, where we spent a weekend mediating with the tower before we've even got to the plaintiffs. And then, of course, I think there's just sort of, you know, the standard, know your case.
Yeah, very good. Thank you. Harold?
You know, Sharon alluded to it, but obviously there can be at least two mediations embedded in all this. And one is to obviously have your client decide what they want to do. But then if they're at odds with the tower or some pieces of the tower, to mediate that dispute so that there is a referee rather than an arm wrestle. You know, obviously, all of the insurance companies are under an obligation to act in good faith. And, you know, that is the tool, coupled with, you know, whatever they've insured, to, you know, to look at whether they are, you know, willing to face the risk of carrying the thing forward without limiting the risk by mediations between the company and the plaintiffs. So the issue of good faith is a tool for defendants who are facing carriers who are reluctant to try to put an early end to some of this litigation. You know, Sharon said that, you know, who the mediator is important. And I think she said she was willing to put that to the plaintiffs. And that also has been my view. Let them make a proposal for the mediator, and then, you know, we'll examine the mediator as to whether they have the credentials to deal with something like this. Because really, in the reality of things is that if two parties come to the mediation table, it is likely that they want to try to resolve this without litigation. And oftentimes, at least from the defense perspective, it seems that the plaintiffs are more unrealistic than we are. I'm sure that the plaintiffs would say, Harold, you know, it's usually the other way around. But in terms of creating your exposure grid, obviously you look at, you know, litigated cases or cases that seem similar that have been litigated to look at the results, or, you know, in situations where there are, you know, cases that have been, you know, set as exemplars and have been tried, you look at those, and you know, classify the kinds of damages that you're looking at, and, you know, it very much helps to have a damage expert or that you're, working with to help you sort through the various permutations of, what you're facing. And again, I think you have to be willing, as Dee said earlier, maybe under the guise of 401, to share some of your expert opinions with the other side so that they see at least where you're coming from. They don't have to, fall over dead when they get your expert's report. Fortunately, no one ever has. But you do have to use you have to take off your litigator's hat, your warrior hat, and try to put on your rational hat to assess where you are. And that obviously requires understanding the other side. And that applies to both of us.
Well, let me say this, that Harold causes me to recall on our journey all over the country. Harold's style was, and I don't know how he does it in his social life, but in his mediation life was to put on some hush puppies, roll up his sleeves, go on with his tie up there at the top. He's got it, but he'd loosen it, and he could talk to anybody. He could talk to, and these various insureds who felt that they were, quote, defrauded, all of a sudden the company became human in the guise of Harold Hirschmann with his hush puppies and casualness. And he was just magnificent in that art of persuasion. But that gets me over to this on the plaintiffs as it relates to these protocols, because the one thing that hasn't been touched upon but is critical, because these are mass actions and we've got certain ethical responsibilities we've got to be aware of. And those ethical responsibilities, you can't just take this large group of plaintiffs and make some decisions for them in an arbitrary way. We've got to have authority. So it's one thing to talk about grids and to try to get those grids in agreement on the defense side, but how do you work that on the plaintiff side in terms of getting your ethical responsibilities and getting your clients on board collectively? Dee, Ted, can you speak to that?
Gee, want to go?
Sure, I'll give a little bit of insight in that and let you go, Ted. I think it's my turn, I'm not sure. So two things you've got to do before you sit down and mediate in a mass tort case. You got to, as we already talked about, you have to grid these. Now, gridding is, great, but you got to put useful information on the grid. And then one of the things we do internally is we grade each case. So maybe you're doing a 1 to 5, 1 being the best, a 5 being the worst. Well, that's an internal grade. You don't really share that with anybody, but you have your grid. So you have a category of which you could drop off when you're sharing it with the defendant, and that will be, where does that case lie on the 1 to 5 range? Got to do that. But more importantly than that, critically important, unless you want to get sued, is that you have to write your client. Once you've graded them, and you write your client and say, we have a number of cases involved in this. We represent more than one plaintiff. They should know that from the beginning. That's usually in the contingency fee contract agreement. And then you write the letter to them saying, we are putting you in this range of settlement. And you'll have it could be a vast range, it could be a very short range. Just depends on the case. And you send that to them and say, if you got a problem with that, call me. If you're okay with it, I'm going to proceed. And you have a deadline. And so if that deadline passes, most of the time you don't get a lot of calls because they trust their lawyer. But one of the problems you do have is they expect a high number. So you're going to have to deal with that later. But those two things you've got to do. And it is an ethical obligation to do that, because the last thing in the world you want to do is get to a global agreement and you got a holdout. And they say, you never told me what my case was worth, or you just threw me into a group. You didn't really represent me, you were representing the group, and my interest was compromised. Well, that can all be eliminated. And this is not coming just from me. I mean, we have long ago, way back in Prudential, consulted, really before Prudential, we consulted with an ethics lawyer, and we got this advice, and we do it every single time there's a mass tort. So those are the two things that we've got to do. There's also an issue about tolling. I'm going to leave that out for now, but because I know Ted has some comments he wants to make. But when you grid these cases, you may have cases you haven't filed yet. That may require an agreement to toll those claims before you enter into negotiations. Ted, I'm sure you have some things you want to add.
Thanks, Dee. So very interesting, the conversation. And I think Harold and Sharon touched on an issue. I just want to go back for a moment because it does dovetail into sort of the plaintiff's mindset going into these issues. One of which, and I think Harold, you referenced that hopefully the defense client, if you will, is rational and understands. And I think as we become more global in all of these, in all of our lives, litigation is no different. So I see more and more international companies, of course, getting involved in these mass cases or class cases. And just in my personal experience over the last 2 to 3 years, dealing with both an Italian company and a French company, the US system is somewhat foreign, no pun intended, foreign to them. And they don't understand the system per se. Like, what do you mean we're getting sued for this? We don't have a responsibility for this, or, you know, the amount of money is crazy or whatever. So there is the education of those clients, if you will. Generally, even the foreign carriers are more understandable of the system and can appreciate it more than some of the clients. So getting everybody on the same page earlier than later is helpful. And I think the plaintiff only has so much ability to do that than the defense attorney. Going back to the specific issue of the grid and getting ready for mediation, depending on the type of case, it can be, you know, I don't want to say easy, but manageable. Some cases can be extremely complex. And I just throw out the Flint case as an example of how complex it can get, because you have a grid where you have, for example, the state of Michigan and the Attorney General's office, who has to deal with the legislators who are providing the money for the state. Then you have insurance carriers and the insurance defendants. You have multiple parties all wanting to be a part of the grid. There's political issues in that case, for example, because the money is coming from the legislature. They want input about how that money is going to be put into this grid and things of that sort. Then you have, as Dee was referencing, you have a potential lot of conflict issues. Sometimes when you have a mass tort, you have also a class action going on. So you have, you know, subclass counsel who have to come in to address the ethical issues. Then in the grid, you may have just a global amount of money. So you really can't tell your clients exactly how much they're going to get, because depending on who participates, they may get more money. So it's a very complex process, and one that takes a lot of time.
Well, let me say this, and it's interesting because we all hear the complexities that you've got, the facts, the law, the interests, the insurance, the different evaluations, and then along comes the identification of a mediator, whoever that may be, that gets brought into this process. So, and now before you're at the table, we're about to get to the table, before you get there, how do you use that mediator to help you internally in each of the rooms? And the experiences I've had have been to really actively engage. You know, we may have full calendars, but we make room for the pre-mediation. Sometimes it's meeting in person. Sometimes it's mediating in a city, taking a day and meet with the group of plaintiffs lawyers, maybe some of the clients, the leadership, meet with the defense. And before we come together in a room to mediate, how do you find using the mediator? Because it is a process that has to build the trust. And it's got to start with a mediator and end with a resolution. How do you deal with that? And I guess with that, you know, I'd start with on the plaintiff side. How do you all deal with that, and then work over to the defense side?
Go ahead, Ted.
Well, sort of along the lines of what we've been talking about is communicating, and communicating in such a way that you bring everybody under the tent to try and get the process rolling. I know I have found, and Rodney, I've done this a lot with you as well, pre-mediation, as you've already talked about, is such an important aspect. And not all mediators spend the time prior to the official in-person mediation to really drill down with all the parties, understand and appreciate the issues, and begin to try and get a feel so that when you get into the in-person mediation, you are far down the field. You're not starting from scratch, and you can make some real progress on the first day. Of course, these cases often take multiple mediations, but at least there's a lot of headway between what the mediator understands, what our goals are, what the challenges may be, and how to express those to the mediator so that the mediator can go to the defendant and explain, you know, sort of the good, the bad, and the ugly of what the plaintiffs are dealing with, and vice versa, of course, for what the defendant is dealing with, whether it's insurance issues, do not believe strongly in the case, all of those type of things. So understanding what the demand is, the basis for the demand, understanding the variety of issues, complex and otherwise, and expressing those to the mediator so that he or she can then express them to the defense and vice versa is very important.
Dee, what are your thoughts in that regard?
I agree. I just think you got to sort of all get on the same track. And I firmly believe that pre-mediation meeting, whether it's Zoom or in person, I prefer them in person, is just sort of, critical to getting the, a lot of communications established. And, I also think it's important, I have this friend of mine who says that 2 people is a meeting and 3 people is a deposition, which is a good piece of advice. So I know you have one of these, one of your ticks on this outline is what happens in the hallway. That's the conversation that I would have maybe with Harold or with Sharon. But that conversation probably needs to occur before we're meeting with the mediator, because there's certain things that, you want to share with the mediator in the room with your adversary, and there's certain things you don't, which is one-on-one. So you'll be having that conversation with your mediator one-on-one and the adversary one-on-one and separate. And then when the 3 of you are together, you sort of already know what the parameters are of what you can reveal. Some things you just can't reveal to the other side. So I do firmly believe that, the mediation with the right people before the process, formal process begins is very important.
Very good. On the defense side, how do you use the mediator to, again, get to the table?
Well, I think that, Dee began by saying, we can share things under the guise of settlement confidentiality with the other side. I think in the same way, I think that in order to prepare a mediator, you want to give them a roadmap, both to the legal issues and the damage issues. And I think you have to think long and hard about that, because the more that is a full picture, the likelier it is that the mediator is going to say to you, why can't I share that with the plaintiffs? And frankly, I think that that's probably a very helpful proposition, that kind of sharing. I know that Rod will say during the course of mediations, well, you just told me that. Is that something that you want me to communicate, or is that just for my background? And you've obviously got to make that kind of decision. But I think that, again, from the mediator's perspective, the more hard information they have about the law, the damages, experts, the easier it is for them to do their job, because it isn't just a matter of their experience or their opinion about certain things. They can point to concrete materials that have to be taken into consideration. And so, you know, I think that it is critically important to have a suite of information, if you will, to share with the mediator before you really begin mediating. I just wanted to say one thing about what Ted said about the internationalization of defendants in some of these cases. We represented a Japanese bank back in the 90s, and it was the first time that they had been in a serious lawsuit in the United States. One of the things they did was commission a translation of the Indiana Civil Code with respect to civil procedure. I'm not sure how useful that was to them, but it was indicative of their willingness to be educated. But it was, especially given our language barriers at the time, a real challenge to handle that education. And whereas you suggested that it was really the defense burden, and I think that's right. Once again, I think the plaintiffs, if they believe they're dealing with a foreign company, and especially a foreign company that does not have experience in U.S. litigation, they might think about finding some national of that corporation who is knowledgeable about, through experience or education, about the American legal system, and literally get an opinion or an article or a letter or whatever that you're willing to share with the defense. And you can say, this may be completely unnecessary, but we'd like you to know where we're coming from. And maybe your client would get some use out of it.
Very good, Sharon.
Yeah, quickly, and I'll note, I think our slides may be stuck,
Yeah.
so if we could move those forward, that would be great. I think we're on question 3 now. But a couple checklist items, and they're in the handout too. I do think during the pre-mediation process, one of the things you absolutely want to be doing is, you know, making sure that your mediator understands what your non-negotiable items are, right? And there we go. And I know Rod is familiar with me saying this is where I can never ever give on. And letting him start to make sure that the people on the other side understand things that are not going to be on the table. You want to know going in what the kind of relief the plaintiffs are going to be seeking is, so you have time and ability to understand that, or is there going to be something that's non-monetary involved? And I think one of the key items always is to be cognizant of any ethical issues, which can vary very much depending on the kind of case. Attorney fees is a key one. There are others. And any particular sensitivities that both sides need to be aware of. I'm happy to know what to not. If someone wants to tell me what I shouldn't talk about in a mediation, it's going to be problematic for their side. I would like to know that as well. And I agree with I think it was Ted who was talking about the difficulties that can be involved in ridding cases. I mean, negotiating a resolution, a mass action resolution to a defective car is very different than negotiating a mass resolution. And it's really not even a mass resolution, it's probably a mass resolution process for if you're dealing with, for example, sexual abuse claims or racial discrimination claims. It's a very, very different process, and the considerations, and really like how hard you may bang on the table, or how hard, you know, what those hallway conversations are going to sound like, is very different. And the more information both sides have about each other's needs, the more likely you are going to be successful when you actually get to the table.
Well, thank you, Sharon. And of course, now that we've gotten ourselves to the table, when we get to the table, and again, is this in a large group setting or are these individual settings? Because again, you've got trying to get the deal done individually or collectively. To what extent are opening statements relevant? They may have already been dispensed with by what you've done preliminarily. You know, the idea of where are we in the negotiations? Has a demand been made? And whose turn is it next? And then, of course, you always have many times in these, not only monetary issues, but non-monetary issues. On the defense side, how do you deal with that? Sharon, you want to pick that up and then go over to Harold?
Sure. I personally, I despise opening statements. I would like to believe that I am not a person who, despite this presentation, is a fan of 100 PowerPoint slides. I walk into every mediation hoping to make everybody feel as optimistic as possible. And it is my both view and experience that getting in and showing how tough you are is a recipe generally for disaster. And that, but these are not always lawyer decisions to be made. And sometimes they're client decisions, and sometimes they're carrier decisions as well. Another value of a pre-mediation process is if you know that you're going to be doing that, to try and calm the waters ahead of time. I do personally think it is valuable, and unless the things have become so acrimonious, and I know Rod's going to agree with me at least on this, that the parties get in, or make cordial introductions to each other, especially if you're dealing with individuals, who have been hurt, and letting them see that there's not just a giant corporation who's there, but there's a human being that cares about the resolution. Nobody ever wants to move first, but that's always a huge consideration. Sometimes, I usually think whoever's making the demand should move first, but I have been asked multiple times to make an offer first. But that's I can usually manage it either way. Though I think it's valuable. I find it valuable to go in with information. I'm sure Ted and Dee agree with me. So, to the extent you get the other side to go first, I think that's helpful. But again, I think it's fair to say if you're going to make a demand, then you should go first. I think you should be, I think when you're there in the room, it's a pretty fluid process. And again, I said I really believe in flexibility, of process, flexibility and resolution to the extent possible. Usually, so if we're dealing with a good mediator is going to be able to do that. A good mediator can take you from an exchange of offers when things stall or things get heated to a different process of resolution. In fact, the very first mediation I ever did in my whole life, when I was a baby lawyer, I was just really more observer and creator of the slide deck at the time, was with the fine mediation shop of Upchurch, Watson and White, which was then Larry Watson, and it was a the $100 million litigation, which at the time was enormous, even for Sullivan and Cromwell. And it was a 2-day mediation where and I learned every trick during those 2 days, from baseball mediation to mediator's proposal to what actually happened at the very end to close this very long and contentious process, which was Larry taking the 2 decision makers together for a walk. And when we came back, we had a deal. I still don't quite know what happened on that walk, but nobody, like, since then, nobody's ever said, I'm taking your principal, you can't come with me, and we're walking. Maybe it was Florida weather, but it was, I think, you know, it's a good idea to have a process in mind, but not to be closed-minded about moving that process. Money, you know, one of the things we have up here is money or non-monetary first or parallel negotiations. I think parallels are usually pretty useful if you're dealing with mass actions and if you're dealing with corporate reform in addition to money. I think in these kinds of mega messes, the more relationships you can create, the more likely your chances are of success. I usually, you know, I recently did a mass action mediation where we absolutely had very, very senior people in the room with plaintiffs' counsel just negotiating a suite of reforms, where a couple of other counsel were with the carriers and the mediator dealing with the money, and ultimately, you know, and then there were the 2 main lead negotiators who, and I know, you know, I'm just waiting for Dee to talk about this, but it's, you know, where all the action happens, which is informally and in the hallway. And so I think, you know, you have to, maybe not the first day or maybe not the second day. Maybe sometimes these mediations take 5, 6, 7 sessions. Sometimes they take a couple of years if they're not together. But a big mediation can go multiple. So I think parallel's good once you get people comfortable with that. And it would be a huge error to not involve your insurers, in my view, throughout the course of the day. You cannot reach, first of all, no matter how many mediations I've done or any of us have done, I guarantee you those carriers have sat through more. They know a lot, and from the defense perspective, you should listen to what they have to tell you. I am a person who believes I am right virtually all the time, but also try to recognize that other people's have things to say can be of great value. And I'm often proven wrong, particularly by carriers who tell me I should do X, Y, or Z. I'm not proven wrong when they ask me to do an opening statement, but other than that, I'm not proven wrong. So yeah, so like looking at our tick list here, I would definitely, those are, I think, sort of key sort of pillars of a day of mediation, and I will let Harold do some flavor.
I just have 2 things to add. In a mediation in San Francisco a few years ago, we were the peripheral defendant, and the mediator said, you'll make all of this go much more quickly if you will throw in X dollars. And I called my client and said, will you throw in X? And he said, yes. And the mediator said to me, I'll never come back to you for another penny. And we sat there the whole day, and at, you know, 6 o'clock, he comes in and says, I need another X dollars. And I said, hey, you promised me you'd never come back. He said, okay, I did. You know, I shouldn't have done that, but I did, and I need X dollars. And I said, well, you know, I don't have authority to give you X dollars, and I have no intention of doing it. He said, you got the phone number of your client in Hong Kong? And I said, sure. He said, okay. And he called him up, and I don't know what he said to my client. Just like Sharon didn't know how the 2 principals came to an agreement, but my guy said, okay. So the net of it is, you know, at some point, you know, from the defense side, always, it's not your money. So the people who the golden rule, the people who have the gold rule. And from the plaintiff's perspective, if they can make a persuasive case, sometimes they get things that even we don't think they should get. And really, that is the net of it. You never know where or how it's going to actually come out.
Very good. Now, on the plaintiff side of that, you're in the mediation, and what are the dynamics that you've got to deal with, realizing it's a fluid process? Dee?
Well, first of all, Harold, I can promise you that I have said many times to the adversary on the other side of a mediation table, it's not your money. What are you worried about? It always work. I'm sure Ted has used that line before.
It's our job.
That's right. That's right. One of the things that I want to touch on that Sharon said, which is, she doesn't like opening statements. I don't either. I think that especially in the type of cases that I'm typically doing, there's usually some hostility among the parties. But sometimes you have to do it for your client, and so that's one of the things that again, I keep going back to relationships and these pre-mediation meetings, because that's really where the juice is, so to speak. That's something that you talk about, and you sort of disarm each other in that meeting. And you say, look, I've got this problem with my client. I think that, the offer should be $300 million. I know it shouldn't be, but about half of that. And, I just want you to know we're going to have to do an opening statement. That way, nobody gets mad, hopefully. But again, the pre-mediation meeting is where that just sort of you disarm each other in that setting. And one other thing that I heard Sharon say that I totally agree with, and that is, as lawyers, we have got to be nimble in these proceedings, because you just can't come in and say that we're not leaving unless we get X. I mean, you're going to learn something in the mediation that you didn't really know beforehand. And I just think it's very important that you remain nimble. I mean, the three things I tell my lawyers all the time: you got to be careful, you got to be thoughtful, and you got to be nimble. And that's for trial or for mediation. And I think those things are things you just got to do to have a successful mediation. Ted?
Well, everything, of course, that Joel said, I totally agree with. Let me just try and touch upon three particular subjects that they always find of interest. First, totally agree on the presentation. I think, I don't want to say a waste of time, but I think our time could be more well spent by talking amongst us on the professional side to get the ball moving quicker. Although there are oftentimes it can be requested by defense counsel. I just finished with a mediation against a huge company. We just got certified in a class case, and now they're taking it, very serious. And the outside lawyer said, we really want you to put on a presentation because the general counsel for the company is going to be there. He hasn't really heard all of this, and he needs to be educated, and we think it would be helpful to do that. So there are circumstances where the defense needs it for their client to, get them in the mindset that, this is serious. Here are the issues. But from a general perspective, I think time can be more well spent. Of course, on the individual side, whether it's, for General Motors, in catastrophic injury case, they always want to make a presentation for a variety of reasons. So those things happen. But I think more on the relationship issue is very important. And I don't think any of us can stress that enough, that having the professionalism and the relationship to work with people on the other side can take these cases and transform them well down the road than they otherwise would be. Some people on the seminar, I think Rod probably knows, for over 30 years, I've been handling complex product liability crashworthiness work, and Dee, I'm sure, knows Luann Vanderwill, who used to be with Chrysler very well, who unfortunately just recently passed away. But Luann had a much different mindset of negotiating very complex, high-end crashworthiness cases than General Motors or Ford did. When she was with Chrysler, you know, they just had a different philosophy, and there was a lot of weeks leading up to mediations on just dealing directly with her or through the mediator. And some of the best mediations I've ever had has always been with her, because she was someone that you could just walk outside the mediation process with, walk down the hall, go get a coffee or whatever, and the case would get resolved, because she was very appreciative of all sides and what everybody was dealing with, and understood and appreciated the issues. And I think when you build up relationships like that, that goes a long way. The last thing I would say is, and I find this happening a little bit more and more, but sometimes the defendants, and probably Harold and Sharon can address this better than myself, but I've seen more recently that sometimes they just have policies that they have to do certain things first before they can really fully entrench themselves in a mediation. There's one case right now where the defendant is, we just have to do certain things in order to get to a place where we can fully ingratiate ourselves in a full and meaningful mediation. So understanding what those issues are, placating the defendant to get them to that place, I also think is helpful, so that there can be true synergy on both sides to get a deal done.
Well, thank you. I know we're getting close to the 1:30 hour Eastern time, which is our cutoff, but your comments have all been invaluable, and I'm going to conclude mine and give you a couple of minutes left. You know, there's the philosophy of never quitting, ever quitting, and mediation may need to conclude on a particular day or days, but the idea of picking that phone up, picking that email up, picking a text, so many ways to continue to engage it. But it reminds me, and I'll never forget, in Birmingham, Alabama, when Dee had to tell me, Rod, I've got to take my numbers off the table because we just can't go there. And that young man on the screen, Harold Hirschmann, ran down to the parking lot, knocked on the window saying, you just cannot do that. You cannot do that. And we ended up, despite the fact that they had to get back on the highway, resolving it. So never giving up. And here we find ourselves back on the screen once again. So my thanks to all of you. If you've got any concluding remarks, we've got a couple minutes. Sharon, anything from you before we conclude?
Just what a pleasure it has been to be with all of you. And I really think we've been talking about relationships, and it's all relationships, and having relationships with all four of you is really valuable to me.
Thank you. Thank you. Ted?
Just to echo what Sharon said, it's been a wonderful chance to get to know everybody better and to work with everyone, and look forward to seeing everyone soon, and everybody stay safe and healthy.
Thank you. Dee?
I feel the same. What a great group this was to work with, and look forward to working with all of them in the future, and especially you, Rod. So
Appreciate
good job putting us together.
Thank you. Harold?
Just thank you, Rod. It was great working with you over time. And I don't know whether we ever shared our nickname for you, which was the Energizer Bunny, but you don't give up.
Well, I appreciate that. Not ever, ever. But, and I also want to thank Kathy Glasney for what she did to help us all get on the screen, stay on the screen, and organize it all. And those attending this session, thanks for your attention. We appreciate it. Any questions? I know we haven't been able to answer any, but you're more than welcome through Kathy to field them to us, and we will get those answered for you. So Kathy, I'm going to turn it over to you in terms of adjourning.
Thanks. If you are a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 220269N, as in Nancy. Again, that's 220269N, as in Nancy. Attorneys in other states will want to check for our follow-up email on May 13th. It will provide instructions on obtaining continuing legal education credit in Alabama, California, Georgia, Illinois, New Jersey, and New York. We're building our remaining webinar schedule for 2022. Please watch your email inbox for news about our future programs. On this slide, you'll see contact information for our presenters and for technical assistance. Thanks.
Thank you, everybody. Good to be with you all. Sincerely. Bye-bye now.
Everyone.